The House will come to order. The Pledge of Allegiance will be led by Representative Lori Garcia Sander.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Shebo, please call the roll.
Representatives Armagost, Bacon, Barone, Byrd, Basenecker, Bottoms, Bradfield, Bradley, Brooks, Brown, Caldwell is excused. Camacho, Carter, Clifford, Representative Clifford,
Excused.
DeGraff, Representative DeGraff,
Excused.
Duran, English, Espinoza, Representative Espinoza,
Excused.
Foray, Froelich, Representative Froelich,
Excused.
Garcia, Representative Garcia,
Excused.
Garcia Sander, Gilchrist, Gonzalez,
I'm here.
Hamrick, Hartsook, Jackson, Johnson, Joseph, Representative Joseph, Kelty, Leader, Lindsay,
I'm here.
Linstead, Luck, Lukens, Mabry, Marshall, Martinez, Representative Martinez, Martinez is excused. Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks. Representative Ricks is excused. Rootnell, Ryden, Representative Ryden. Ryden's excused. Sirota, Smith, Soper, Representative Soper is excused. Stewart K, Stewart R, Story, Rep Story is excused. Sukla, Taggart, Tatone, Valdez A, Representative Valdez. Valdez is excused. Velasco, Weinberg, Wilford, Winter, Woodrow is excused. Woog, Zokai, and Madam Speaker. And Clifford, Ryden, Espinoza. Yep.
With 56 present and 9 excused, we do have a quorum. Representative Garcia Sander.
Thank you, Madam Chair. Oh dear, said the cat, you did not like our game. Oh dear, what a shame, what a shame, what a shame. And I had them at last. Those two things had to stop. Then I said to the cat, now you do as I say. You pack up those things and you take them away. Shame. That is good, said the fish. He has gone away, yes, but your mother will come. She will find this big mess, and this mess is so big and so deep and so tall, we cannot pick it up. There is no way at all. Then he shut up the things in the box with a hook, and the cat went away with a sad kind of look. And then, who was back in the house? Why, the cat. Have no fear of this mess, said the cat in the hat. I always pick up my playthings, and so I will show your mother a good trick that I know. Then we saw him pick up all the things that were down. He picked up the cake and the rake and the gown and the milk and the strings and the books and the dish and the fan and the cup and the ship and the fish, and he put them away. Then he said, that is that. And then he was gone with a tip of his hat. And Sally and I did not know what to say. Should we tell her the things that went on here that day? Should we tell her about it? Now what should we do? Well, what would you do if your mother asked you? Tip of the hat to the cat in the hat.
Woo!
It
Applause.
is Read Across America Day. Pull out your old Dr. Seuss and give it a read. Madam Speaker, I move that the Journal of Tuesday, March 4th, 2025, be approved as corrected by the Chief Clerk. I'm sorry, Monday. May I correct?
Yes.
Madam Speaker, I move that the Journal of Monday, March 3rd, 2025, be approved as corrected by the Chief Clerk.
Excellent. Well done. Members, you've heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. No. Ow! I love it. The ayes have it. Members, we are moving on to business. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be added to the special orders calendar on Tuesday, March 4th at 9:11 a.m. House Bill 1011, House Bill 1200, House Bill 1168, House Bill 1148, and House Bill 1179.
Seeing no objection, the bills listed by the Majority Leader will be added to the special orders calendar on March 4th, which is today at 9:11 a.m. Representative Clifford. Seeing no objection, Representative Clifford will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the Cote rule is relaxed. Madam Majority Leader.
Thank you, Mr. Chair. I move that the House Bill 1116 and House Bill 1014 be laid over to the end of the special orders calendar.
The bills will be laid over. Mr. Sheba, please read the title for House Bill 1011.
House Bill 1011 by Representatives Garcia and Sirota, also Senator Kipp, concerning requirements for child care centers owned by an institutional investment entity.
Representative Sirota.
Thank you, Mr. Chair. I move House Bill 1011, the Health and Human Services report and the Appropriations report.
To the committee report.
Oh, sorry.
Oh,
just
to Health and
Human
Human Services Committee report.
Thank you, Mr. Chair. In Health and Human Services, we made significant changes to the bill. We did add an explanation as to why we are proposing this legislation, and we removed the link to public funding, and now what is reflected in the bill is a definition of institutional investment entities in child care and a requirement to be transparent in the posting of tuition and fees, and a requirement that when an institutional investment entity acquires a child care facility, that they are required to provide 60 days notice to parents and families in the event of layoffs or classroom closures. And we also provide the department with the ability to gather certain financial information. And we do have an amendment.
Representative Garcia.
Thank you, Mr. Chair. I move L007 to the committee report and ask that it be displayed.
That is a proper motion. It has been properly displayed. Representative Garcia.
Thank you, Mr. Chair. Members, excuse me, members, this is a technical amendment that we just had to change the number of a section from section 1 to section 2, and that is it. And I ask for an aye vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the passage of Amendment L007 to House Bill 1011. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Amendment 7 is adopted. To the committee report. Representative Bradfield.
Thank you, Mr. Chair. I move Amendment L006 to the committee report and ask that it be displayed.
That is a proper motion. The amendment is displayed. Representative Bradfield, please tell us about the amendment.
Thank you, Mr. Chair. This amendment strikes a requirement of providers to post fees on a website and instead replaces with language to require providers to provide a fee schedule upon a family registering or signing up for a wait list. The language will match SB4 language, which was heavily stake-held among providers in the Senate for Senate Bill 004. This amendment seeks to expand the bill's protection to all families and staff and match the language on pricing transparency to a bill that has passed the Senate and, as I said before, was heavily stake-held. Specifically, this amendment expands the definition of child care providers to provide protection and transparency to all families who need child care or who are already enrolled in child care program, as well as all center-based teachers and staff. Do you hear the resounding word that I repeat over and over again? That word would be all. Next, this amendment aligns the fee transparency requirements to a bill that has already passed the Senate and has been significantly stake-held. That would be Senate Bill 004. It requires that centers offer families information on fees when they join a wait list or enroll. And finally, this amendment removes the financial audit requirement. I ask for an aye vote on this amendment.
Representative Garcia.
Thank you, Mr. Chair. And members, I urge a no vote on this amendment for multiple reasons. Number one, the transparency requests are already practiced. They're already in law. Number two, the expansion from just focusing on private equity to all providers is actually does not fit within the title. I also want to acknowledge that the reason why this bill is very specific to private equity, as we will continue discussing throughout this morning's debate, is that there are very specific practices that private equity engages in that are not relevant to all providers. And so I just urge a no vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L006 to House Bill 1011. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. The amendment fails. To the committee report, Health and Human Services Committee report. Representative Minority Leader Puglisi.
Thank you, Mr. Chair. And I want to thank the bill sponsors for bringing this bill. I think this is an important conversation to the child care provider conversation. Obviously, we're all trying to help working parents, and so really do appreciate you bringing this. I think that there are some ways we can work together to make the bill even better, and therefore I would move Amendment L005 to the Health and Human Services Committee report and ask that it be properly displayed.
Thank you. That is a proper motion.
Thank you, Mr. Chair. Just to tag along with what the good representative from El Paso County was talking about, we do think the ability to apply this to all child care providers and child care centers is incredibly important to increase transparency and ensure that ample notice is given for layoffs and disenrollments. I want to say I agree with the importance of transparency and ensuring that this notice is given. So I want to be very clear that I support that part of the bill. We just think that it can be expanded to add these important provisions to help more Colorado families and workers. And with that, I would ask for an aye vote. Thank you.
Is there further discussion on the amendment? Representative Sirota.
Thank you, Mr. Chair. We ask for a no vote on this amendment. It's along the same lines as the last amendment, and you know, this language, which is referred to already in the committee report, that's what's in the committee report. It's just that this is a cleaner way of referencing another bill that is moving through the system, and if it encounters changes, it's easier to reflect that in this bill by citing the statute that it is creating so that we don't have revisions that we have to make along the way. But we also think that the disclosures to families when an acquisition happens, if there are going to be changes to staff or classrooms, that families and staff ought to have notice, and that that is an important component of our bill. So ask for a no vote.
Is there any further discussion on the amendment? Seeing none, and before we vote, if you could keep it down in the chamber, the last vote was very close to the chair, so I need to be mindful of who is voting. Thank you. The question before us is the adoption of Amendment L005 to House Bill 1011. All those in favor say aye. All those opposed, no.
No.
The noes have it. The amendment fails. To the Health and Human Services Committee report. Representative Sirota.
Thank you, Mr. Chair. We have one more amendment in response to a colleague's inquiry. Sorry, we have one more amendment in response to a colleague's inquiry about the language in the committee report. So I move L008 and ask that it be displayed.
That is a proper motion. We'll wait until it's displayed. Representative Sirota.
Thank you, Mr. Chair. So this amendment strikes in section 3A the words "upon acquisition of a child care center" because it was pointed out to us that what our goal is to ensure that the 60 days notice happens, and we want to make sure that it is not specifically linked to the date of acquisition, and that that actually applies broadly so that an acquisition could occur, planned layoffs could happen, but that could happen sometime down the road. And so ask for your yes vote for clarity's sake here.
Is there further discussion on the amendment? Seeing none, the question before us is the amendment of the adoption of Amendment L008 to the Health and Human Services Committee report. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. The amendment is adopted. To the Health and Human Services Committee report.
I ask for an aye vote.
Seeing no further discussion on the committee report, all those in favor say aye.
Aye.
All those opposed, no. The Health and Human Services Committee report is adopted. To the, will you make the motion again for the other committee report? No, sorry.
No appropriations.
No,
report.
no
There's
appropriations. Thank you very much. To the bill. Representative Garcia.
Thank you, Mr. Chair. Members, it is an honor to bring this bill forward because it is important that we are putting the quality of care and the standards of practice in the entities in which many of our youngest residents are being cared for to the highest standard. Private equity, unfortunately, does not do so well when they take over many of our public service intended services. We have not seen healthcare or nursing homes improve because of the acquisition that private equity has done to our centers. While we have a 10% rate of private equity-owned child care centers, we know that because Colorado is struggling to fund our early childhood programs, we are unsure of the support we're going to receive from the federal government, that leaves Colorado prime for increased private equity investment. I want to be clear that this bill is not saying no to private equity. What this bill is doing is actually quite small in the sense of requiring transparency from private equity. When you are coming in and you are buying a child care center and you are making changes in order to fit your profit model, that you need to be transparent about what that is. If you are going to be changing the classrooms that you are housing, if you are going to be terminating and laying off teachers, if you're going to be changing eligibility, if you're going to be eradicating CCAP, you need to be transparent with families. This bill has been stake-held. We have received feedback. We have responded to the feedback. We are talking about private equity very specifically because private equity is a very specific business model. Within our early childhood licensing scheme, we have different expectations for different licenses for centers. So why is this so different when this business model is fundamentally different? than other models of childcare. It is okay that we have different standards for different business models. It is okay that we expect transparency, and it is okay that we expect when a for-profit entity is trying to come in and profit off of our kids that we set standards. You have heard reference to Senate Bill 4. I am a prime sponsor of Senate Bill 4. I understand the fundamental difference of having child care standards across the board while also targeting. And what this bill is doing in a narrow fashion, it's targeting the specific business model of private equity in our child care system, and I urge an aye vote.
Representative Sirota.
Thank you, Mr. Chair. I want to express my gratitude for my colleague from Adams County inviting me to join her in this work. We started working on this bill maybe late summer, early fall, as news reports began in the state. Well, I should step back and say this is a national issue that has brought national concern. But here in Colorado, the Colorado Press Corps has been doing its work reporting on the activities that have occurred when private equity institutional investors have been taking over child care businesses in the state. And we have multiple examples of family and staff being left high and dry. I can point you to the Colorado Sun report in October, recent reporting from Denver 7, recent reporting from Chalkbeat regarding the most recent occurrence of closures that happened due to institutional investment entities buying up locations, expanding too fast, and then closing all of their Colorado locations practically overnight, leaving families to scramble looking for care for their infants and toddlers. And all we are doing in this bill is attempting to say this is a statewide interest, this is a statewide concern that our Department of Early Childhood should have an eye on, should be able to wrap its arms around to ensure that it is collecting enough data, putting enough protections into statute to protect our families and our child care workers, and ensure that we are able to monitor a situation before it gets to the point where private equity and institutional investors are owning a significant enough segment of our child care sector that the collapses that we are seeing will have catastrophic ripple effects across the entire industry. So these are very small, important consumer protection transparency requirements that we are asking for in this bill because this business model is different from all of the others, and we should watch it in such a way that reflects that it is different. I ask for an aye vote.
Seeing no further discussion on House Bill 251011, the question before us is the adoption of House Bill 251011. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The bill is passed. Mr. Shevil, please read the title to House Bill 251200.
House Bill 1200 by Representative Ferre, also Senator Cutter, concerning modifications to the Office of the Child Protection Ombudsman.
Representative Ferre.
Thank you, Mr. Chair. I move House Bill 1200.
To the bill.
Thank you, sir. This bill historically was under CDHS and is now a standalone department. So with that, we needed to adjust some language and move it over to update the statute. There are two things that are fundamentally important in this bill. One is that you improve access to records, and we are clarifying those records in an amendment. And the other part is that they have access to youth held in detention facilities at an earlier time. So those are the two main things of this bill that I wanted to bring up to you all. I'm very supportive to have bipartisan support here, and I will let you speak if you have anything to say.
Representative Armagost.
Thank you, Mr. Chair. So yeah, I'm happy to have had something to do with the Ombudsman Office in the last session, so I'm happy to continue this and continue the work in taking care of kids, and good to make this a bipartisan bill and encourage a yes vote.
Thank you.
Representative Ferre.
Thank you, sir. To address some of the feedback from our committee testimony, we have 2 amendments we'd like to run. So I move L0001 to House Bill 1200 and ask for it to be properly displayed.
That is a proper motion. We'll wait for the bill to be displayed.
Rookie moves.
That bill is displayed. Representative Ferre.
Thank you, Mr. Chair. This amendment just clarifies some of the concerns around what records the ombudsman can access. So attorney-client privilege, personnel records, and work files are excluded from accessing records with the ombudsman, and that's just clarifying language, and that is this amendment. I ask for an aye vote.
Seeing no further discussion on Amendment L001, the question before us is the adoption of L001 to House Bill 1200. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. Representative Ferre.
Thank you, Mr. Chair. I move L002 to House Bill 1200 and ask for it to be properly displayed.
That is a proper motion. It is displayed. Representative Ferre, please explain the amendment.
Thank you, Mr. Chair. This amendment just allows for the ombudsman to have access to the training since they're going to be working more intimately with other departments and some of these individuals. This gives them access to the training that others have as well. I ask for an aye vote.
Seeing no further discussion on Amendment L002, the question before us is the adoption of Amendment L002. All those in favor say aye. All those opposed, no. The ayes have it. The amendment is adopted. To the bill, Representative Ferre.
Thank you, Mr. Chair. This is a great bill. There's no fiscal note. It's bipartisan support. This allows the Ombudsman program to further their support, their investigation capabilities for children in youth detention centers. So I ask for your support. Thank you.
Is there any further discussion on House Bill 1200? Seeing none, the question before us is the adoption of House Bill 1200 as amended on second reading. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The bill is adopted. Mr. Schiebel, please read the title of House Bill 1168.
House Bill 1168 by Representatives Lindsay and Espinoza, also Senator Weissman, concerning housing protections for victim survivors of gender-based violence.
Representative Espinoza.
Thank you, Mr. Chair. I move the adoption of HB, well, actually, I have an amendment.
Go to the committee report. Let's move the committee report first.
Yes.
And the bill.
And the bill. So to the committee report, we came through the committee without any amendments, I believe, in the committee report.
Representative Espinoza.
Yes. Sorry. I'm, Mr. Chair, I move House Bill 1168 and the committee report.
To the committee report, Representative Espinoza.
The committee looked at this bill and we came out of committee. I don't believe we had amendments there. I will be asking for amendments on the floor.
Just for clarification, is the amendment to the committee report or to the bill?
Oh, to the bill, sorry.
Okay. Is there any discussion on the committee report? Seeing none, the question before us is the adoption of the Transportation, Housing, and Local Government Committee report to House Bill 1168. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. To the bill, Representative Espinoza.
Yes, Mr. Chair. I move HB 1168L005 and ask that it be properly displayed.
That is a proper motion. We'll wait for it to be displayed. The amendment is displayed. Representative Espinoza.
Thank you, Mr. Chair. In the course of the conversation at the committee, we talked about the fact that the attestation that we provided in the bill did not completely comport with the VAWA amendment affidavits, and this amendment will allow for additional evidence should it be required by the landlord. It also brings the attestation clause that's in our current bill to agreement with the VAWA standards, which has been proven to be very effective in ensuring that no fraud occurs. We'd ask for a favorable vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of L005 to House Bill 1168. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. Representative Espinoza to the bill.
Thank you, Mr. Chair. I move HB 1168L006 and ask that it be properly displayed.
That is a proper motion. We'll wait for it to be displayed. Representative Espinoza.
Thank you, Mr. Chair. In this amendment, one of the things that this bill had provided is if an individual is a victim survivor of domestic violence, that individual would be given 18 months in order to create a repayment plan and not be evicted from their homes. What we've heard in terms of communications is that a 12-month period would be better. Therefore, we're recommending an aye on moving the date from 18 months to 12 months for the repayment plan as anticipated in the bill.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L006 to House Bill 1168. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. To the bill. Representative Wu.
Thank you, Mr. Chair. I move Amendment L007 and ask that be properly displayed.
That is a proper motion. We'll wait for it to be displayed. The amendment is displayed. Representative Woog, please explain the amendment.
Thank you, Mr. Chair. And this was discussed with the prime bill sponsors, and this was my industry for many years. This will simply make it, the tenant will have the ability to change the locks on their own, but landlords do need a copy of the key for insurance purposes, for emergency purposes. So that was not in the bill, that once the tenant, if they change the locks, that they need to provide the landlord with a copy of the key as soon as reasonably possible, and that's what this amendment will do. So I urge a yes vote.
Is there any further discussion on Amendment L007? Seeing none. Oh, Representative Espinoza.
Mr. Chair, I do agree that this was discussed in committee, and I appreciate the amendment and the amendment's inclusion, that if the alleged abuser is a person who would be the landlord, that is also protected in this amendment, so I urge an aye vote.
Seeing no further discussion, the question before us is adoption of Amendment L007 to House Bill 1168. All those in favor say aye. Aye. All those opposed, no. The amendment is adopted. Is there any further discussion on the bill? Oh.
Yeah.
Representative Richardson.
Thank you, Mr. Chair. Well, I appreciate the issue that's trying to be addressed here, and I do grieve for those that are victims of domestic violence. I did have some concerns in committee because the actual title of the bill is Protections for Victims of Gender-Based Violence, and being gender-based and not defined in the bill potentially leaves out protections for same-sex couples. There's some other pieces here again where, though we're trying to address and make whole victims of crimes, we're doing that again on the backs of small business people and landlords. And it does leave open potential where there's damage to an apartment where either member of the couple or both members can claim that the other member of the couple was the cause of the damage or the instigator of the incident, and leaves the landlord to determine kind of who's at fault and what really should be a criminal investigation. So again, I think the issue is correct. I think there's some flaws that need to be addressed, and would urge a no vote on this. Thank you.
Representative Woog.
Thank you, Mr. Chair, and I do appreciate some of the work and discussions with the co-primes on this bill. However, I also will be a no vote, and I do want to explain my reasoning. So, I come from a family of entrepreneurs. My great-grandfather, he came here from Germany, left his oldest son behind and his wife, and he started a cement laying business in a blue-collar town, South St. Paul, Minnesota. My late father, he also started a business with my mom, and worked their tail off making physical therapy products and trying to get the word out and selling those products. And then, of course, I followed in those footsteps and started a property management business, residential property management business. And I was a small business owner, had anywhere between 30 and 60 properties at a time, and it was a ton of work. This wasn't 40 hours a week. This was 80 hours, 100 hours. You might get calls in the middle of the night. That did happen too. So as a small business owner, this is a difficult bill for me to vote yes on. It's an emotional bill. And as Representative Richardson said, we certainly feel for these victims. I'm sure we all do. I can't even imagine, but I do know victims. I've been friends with victims of abuse, and I feel for them, and we all do, like I said. My instinct is that we go after the assaulter. To me, this is the guilty party, the one who assaults that victim. And really, this bill is punishing the wrong person. This is going after, and maybe not intended to, but this is really hurting that small business owner that's managing these properties or this property. Some of these landlords have one property. They're the owner of one investment property. So this can become a financial struggle for that landlord. Not only a financial struggle because of the delays on getting rent, it can also be, it's a huge time commitment. Whenever something like this comes to fruition, and a good landlord like myself and many others, they're gonna try and work with this tenant who's a victim. This really completely takes your mindset of every day. You know that this person's in a very difficult spot, and you're gonna focus on this so much and leave all these other things on your plate, they become secondary. And it happens in a lot of different ways. You might get an audit. I'm talking small business owners. You have to put everything into this. So this is a huge, huge time constraint, and a lot of times other things in your business falter. Other people you're supposed to be helping, they become secondary. This becomes a huge, huge time commitment. And again, it should be, this is a horrific situation we're talking about. I have a few notes. I'm not gonna go over all of them, there's a lot. But just some issues I have with the bill as is written. Again, I question who this is. It's really punishing the landlord, the small-time mom-and-pop business owner. There's some wording in here. I'm going to read this to make it easier what I'm talking about. Gender-based violence perpetrates cycles of poverty and imperils the victim survivor's economic stability by endangering or preventing employment. So, I just wonder, are we going to have another bill this session? Because if we're truly worried about these victims, is there another bill coming that will mandate employers pay this abused victim because they can't go to work now? And I'm sure that happens. So I'm wondering if we will see that. That's important. The General Assembly intends to preserve victim survivors' due process rights. That's great, they have rights, but so do I as a small business owner. What about the rights I have? It seems like we're picking winners and losers here. And again, we certainly feel for these victims, but I don't understand why we're choosing winners and losers and why I need to be punished as a business owner. We have a section 4A, is not an unlawful detention of real property as described, subsection, I'm gonna skip those, of this section if the tenant or leasee, a victim survivor of unlawful sexual behavior, stalking, domestic violence, domestic abuse, which unlawful sexual behavior, stalking, domestic violence, or domestic abuse was the cause of, contributed to, or resulted in the alleged unlawful detention, and which unlawful sexual behavior, stalking, domestic violence, or domestic abuse has been documented by at least one of the following: a police report, a valid civil, criminal, or emergency protection order or restraining order issued pursuant to Article 14 or Article 14.5 or Title 13 or Section 18-1-1001. I'm concerned this bill leaves out a key component. If this victim, at what point, what's the time frame? If this victim was abused 5 years ago, and I don't downplay that, there's still much trauma. They may be having trauma. They may be having trouble in life. They may be having trouble getting to work because of their PTSD and what they're going through. So what's the time frame on this bill? I struggle with that. Did this incident, abuse, happen within a couple months? Was it 8 years ago? Because again, they may be sincerely struggling from a long, long time ago. So I'm concerned, and if it's in here, please correct me, but that is a big question mark for me, that we don't know if this is recent and they're dealing with something head on right now, or if it's past. Maybe that doesn't matter to all, but that's a concern I have on this bill. Okay, we have another section here. A landlord's failure to offer a repayment plan pursuant to this subsection is an affirmative defense to an action for unlawful detainer. The repayment plan must be structured at the tenant's discretion and must include at a minimum a requirement that the tenant pay the full payment or full repayment of all lawfully owed rent and make payments on a monthly basis, and the repayment plan must include the amount that must be paid on a monthly basis. The repayment plan, and I think this is what you changed, must not exceed 18 months. Is it 12 months now? From the date the plan is established. So this is a struggle again for these small business owners that might have one rental or two rentals. They're expected, they probably have a mortgage. A lot of them do. A lot of my former clients had one property and they had a mortgage on it and they relied on that rent coming in. And hopefully they had a couple months that if something happened, they could pay rent, but 12 months could really get difficult for people. They might actually have to sell their property at this point. So again, this unfortunately is a punishment for small business owners. So a landlord, another section. A landlord shall not charge a tenant any fees, interest, or penalties associated with the repayment plan. I feel that that's, again, government picking winners and losers. We're punishing someone for something that's not in their control or their fault. We feel for these abuse victims, absolutely no question, but should we be, as state legislators, punishing this person that's simply trying to provide housing in a fair way? The tenant must not be unfairly penalized or suffer the undue loss of housing due to the acts of the responsible party. Landlord does not have a basis for possession pursuant to this section if the tenant or lessee is the victim survivor of unlawful sexual behavior, stalking, domestic violence. So again, it's the tenant can stay, the landlord has no say over his property. Is that, or her property? Is that their property anymore? It's almost like they don't even own the property. They have no say. They're not the one that assaulted someone, but yet, as legislators with this law, we're punishing them unjustly. I'm just going to start in mid-sentence so I don't read you guys 2 paragraphs here, but in case no one is on the premises after attempts at personal service at least once on 2 separate days. So this is about delivering notice to a property. Back in the day, there was 1 notice required for some instances. This wants, and we had a bill on this wants 2 separate days, and another bill this session, I should say. So now you're putting a landlord at risk going to a property where there may be a physically abusive person, and you want them to go to the door and ring the bell or knock on the door subsequent days. So you go deliver 1 notice, and now guess what? If they don't answer that day, I'm required to go back as a landlord and put myself at risk, possibly, with a very violent, abusive person in that household, trying to knock on the door, ring the bell to make sure they get the second notice. So I think that, again, that's kind of punishes the landlord or the small business owner. And just going back to what I said earlier, one more point, because I found a paragraph on it, and then I think I'll wrap it up. So thank you for listening. Well, there might be a couple more, not too many. If a defendant provides the plaintiff with written or actual notice that the defendant is a victim survivor of unlawful sexual behavior, stalking, domestic violence, or domestic abuse, the plaintiff shall only perfect service through personal service to the defendant who provided the written or actual notice. And again, I question, when did the abuse need to take place? Does that matter? It might have been 10 years ago, and there's, like I said, PTSD, understandably so, and they're just struggling to go to work and get an income to pay rent. So I do think that's an important part of this bill that I'd like to see some changes or amendments. So on security deposit, tenant is not liable for damage to the dwelling unit caused by the responsible party. Okay, so how do we know who caused the damage? I mean, it would be very easy to say that the abuser caused the damage, but how do I know, as the owner of this property, I have one property, I'm struggling to pay my bills too, but how do I know that the abuser did this? How do I know it wasn't, it could be anyone. It could be the victim, it might be the victim's kids, it might be family. We don't know who did the damage, so that would be a pretty easy argument, and I fear that a judge is, if it's unjust, might just lean towards the victim. It would be hard not to, but what if it was this person that actually caused the property damage? The property owner, the small business owner, the mom and pop landlord, they're not going to know who caused the damage. So now that's on them. That's definitely a difficult part of this bill that I can't come to agreement on. I think I'll wrap it up, and I appreciate whoever listened for you listening. I really, truly appreciate the intent of the bill sponsors. We certainly all feel for these victims. There's no question about it. I wonder what's next. I mean, I wonder what happens if this victim has a mortgage payment. Do they get let off the hook on the mortgage payment for a certain amount of time? If they have a car payment, do they get let off the hook on a car payment? If they have utility payments, do the utility companies, are these more bills coming, or is it just pinpointed this year and maybe forever on small business owners such as landlords? That greatly concerns me. It doesn't seem fair. I don't know why it seems like we're targeting a business that I used to do and a business that I worked very, very hard for, and a business that I tried to always work with my tenants and do what's best for them and work with the owner of the property and let them know situations so that we could make it better for them. So that's the free market approach. That's my approach, and that's why I will be a no vote on this bill, respectfully.
Representative Barone.
Thank you, Mr. Chair. Good morning, fellow colleagues, and for the millions watching at home. I also stand up here against this bill, not because it's not well-intentioned. I understand it's well-intentioned, but there is unintended consequence to this bill to the small business owner like myself. I own 2 small rental properties. This bill would, while it's well-intentioned, would come with unintended consequences towards me and my business. My wife and I opened this small LLC to help people. We understood the need for people that could not qualify, but could afford a new home, but they cannot qualify due to credit or any other reason. So we opened this business and we opened these 2 rental properties for that reason, to help those people build their credit and be able to have a roof over their head. I'm not making thousands of dollars at end per month. I'm not. I'm charging the minimum plus a little bit extra to be able to have something just in case something goes wrong with the home. I have something there to be able to fix it because that is my responsibility. I'm also responsible for the non-potable water system to water the lawn during the summers. So I pay for that. I pay for the garbage disposal. I'm in charge of everything else, so the tenant only pays for rent. That rent pays off the mortgage. This bill, what it would do, the unintended consequence is it would back me up on that mortgage payment. I would have to either dig into my reserves, which is intended for emergency uses of the home that I am responsible for, or I back up on my mortgage and probably lose my house. And in turn, the tenant will lose the home because the mortgage company ain't going to give them time to pay for it. It's not under their name, it's under my name. I would lose the home. One less rental property on the market. So my intentions and the intentions of these small business owners and landlords like myself is to help people. Of course, I am building on my generational wealth as well. I now have 3 homes, 1 where I live and 2 rentals, to 1 home for each one of my children. So I have something for my children to be able to live in once they grow up, if needed. That was the intent of my wife and I's business model. help somebody build their credit so they can afford their home in the future while they have a home to live in, and at the same time have something for our children to have for the future. So, like I said, we really do care for the victims of these heinous crimes, but this has unintentional consequences towards the small business owner that I don't think is fair, to be honest. It's, yeah, like my colleague said from Weld County, it's picking winners and losers. And my wife and I worked hard for this. We did. We worked very hard to build this business, worked very hard to be able to do this. I do all my accounting myself. I do everything myself because we're not making money off of this. We're really not. We're keeping that money in that account just in case those homes need some upgrading, they need some repairs. So it's really a well-intentioned bill with unintended consequences, and I urge a no vote. Thank you.
Representative Johnson. Oh, I am so sorry. Representative Garcia Sanders. One of these days.
Just don't call me late for dinner.
I will not.
Thank you, Mr. Chair. I am just going to kind of speak globally to this bill. Every time we pass bills that affect the small landlord, small business owner, I have one rental. My husband and I, when we got married, I took the income from my house and bought a small rental. It's right next door to our house. I know teachers, lots of teachers who use their nest egg. That's when they retire, they want to have a small little income. Every time we pass bills that hurt the single mom and pop rental owner, it just takes more properties off the market. We won't be renting our property after our current tenant moves out. We'll probably Airbnb it or we'll rent it to a friend, but every time we have more to worry about that is going to come back on us, just as mom and pops, it stresses us out and it actually decreases the properties that are out on the market. So I just want people to really think thoughtfully about every time we pass the mom and pop, the bills that hurt the mom and pop landlords, it does take properties out of the rental market. That doesn't help those who need affordable rentals. It just hurts. So thanks for being thoughtful and considering amendments.
Assistant Minority Leader Winter.
Thank you, Mr. Chair. It makes it really tough in rural Colorado. We have hard enough time finding housing as it is, and we see more and more people getting out of the market because rent is a little bit different, and rent costs are a little bit different where I'm from than they are here in Denver. And the issue I take with this is there's people surviving on a small margin as it is. And like my colleague said earlier, a lot of the savings that people put together are for emergencies. A water heater goes out, a repair on a water line, a refrigerator, and they're having to dip into that. And like my good colleague from Weld County said, at the end of the day, they're going to be coming knocking on his door for the payment. They're going to be asking him for the payment, and then all the work that he's put in, first of all, attaining the property, which a lot of times is for retirement, which I think in America that's a good thing for us. But you take all that time to acquire the property, and then it's really upsetting because we have so many really good landlords. And I think that a lot of times, a lot of this legislation is very narrowly focused on what we hear in the building a lot of time is slumlords or those that just don't feel like they do a good job. And I'm not saying that those people aren't out there. But at the end of the day, a lot of the people where I'm from, they're good. I say it all the time, salt of the earth people, and they're just trying to get by. And especially in rural Colorado where this is really hard is our infrastructure is aging. A lot of the homes are getting older and older with less new builds, which means there's more and more required to keep those homes going. I know landlords now, they're replacing windows to be, more energy efficient and keep the house warmer. I know now a lot of what we talk about is a lot of like furnace replacements. It's happening because these homes are aging out. And this just, this takes an act of God, which is unfortunate. And, at that point, I feel horrible for the people that are going through the crisis. But at the end of the day, it's taking something bad that happened to them, and then it's transferring that bad onto somebody else. And a lot of times it's the people that are trying to help them the most, the people that are trying to keep them housed. And it's just unfortunate that we're putting landlords in this situation. I think that it'll affect rural Colorado way more than it'll affect the Metroplex. And even though legislation is well intended, big city fixes exasperate rural problems, and for that reason, I'll have to be a no.
Seeing no further discussion on House Bill 1168, the question before us is the adoption of House Bill 1168 as amended. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The bill is adopted. Mr. Schiebel, please read the title of House Bill 1148.
House Bill 1148 by Representatives Bacon and Carter, also Senator Gonzalez, concerning protection orders.
Assistant Majority Leader Bacon. Assistant Majority Leader Bacon.
Thank you. Sorry. I move House Bill 1148 and the Judiciary Committee report.
To the committee report. That's okay. Would you want me to wait a second?
I'll keep going.
Thank you. Assistant Majority
right.
Leader Bacon.
Thank you. Members, in Judiciary Committee, we amended the bill to help bring down our fiscal note, and we also made two very important amendments to carve out exceptions to this, particularly for those who would have protection orders against offenders for domestic violence and VRA crimes. And so with that, members, we ask for an aye vote on the committee report.
Is there any further discussion on the committee report? Seeing none, the question before us is the adoption of the Judiciary Committee report to House Bill 1148. All those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill, Assistant Majority Leader Bacon.
Thank you, Mr. Chair. Members, House Bill 1148 is about being able to clean up our system around protection orders. When one is arrested for offending, the victims and witnesses could be issued protective orders to keep the offender, within distance of them. We were finding in our system that there is currently a mandatory arrest provision, particularly around drugs and alcohol, even if they were not being used at all, just possession, or used illegally. And so what this bill does is it returns discretion to law enforcement to arrest someone as long as there's some sort of nexus to the behavior that is violating the protection order, which again is like drugs and alcohol use, legal drugs and alcohol use, and connection to the underlying crime. And so what this bill does, again, is instead of saying that it's mandatory that one must be arrested if they have, even beer, we're saying that it can be discretionary.
Representative Carter.
Thank you, Mr. Chair. Just to expound on what my colleagues indicated, for those who don't know, I am a criminal defense attorney, and one of the conversations that I've had many times with some of my clients includes an individual who is arrested on a protection order that is either not connected to the nexus of the individual that needs to be protected, or that has already been expunged or is no longer in place. It's just still on a computer system. One of the things that happens with protection orders, as my colleague has indicated, it is an automatic arrest. So there are individuals who have done everything they're already supposed to do. They've already completed their sentence, completed their probation, completed whatever was part of the underlying protection order, and they still get taken into custody. Eventually, it may be sorted out, but an individual being arrested for a case that should be closed, it becomes a hardship, and it's a hardship on a particular community, one of the reasons that I'm on this bill. Further, as we indicated, when the nexus to the protected party is a reason an individual is taken into custody, it also becomes an issue with certain parties in which now you have to give up a day of work, you have to be taken into custody, you have to bond out, you have to see a judge. All this bill does is taking what we've heard from law enforcement, and we've done a lot of stakeholding, gives that officer the discretion not to take an individual into custody.
Assistant Majority Leader Bacon.
Thank you, members, and with that, we urge an aye vote.
Representative Soper.
Thank you, Mr. Chair, and it's an honor to serve with you.
And an honor to serve with you.
Members, in committee I was a no vote, and a lot of that was because there were a number of amendments that we adopted in the committee report that we were still adjusting to how they actually interacted with the bill itself. Our initial fear is that 81% of Colorado's victims have a perpetrator that uses drugs or alcohol. And as a protection order includes drugs or alcohol, prohibiting that use, that if you violate that, I mean, if you're having one beer, you're likely to have the entire 6-pack or 12-pack or whatever pack it comes in, and then do things that perhaps that person would later regret, such as interacting with the person who's covered by the protection order. And that was our real concern, that we wanted to make sure that victims were protected. But at the same time, I will say the sponsors brought up a really good point, which is it's legal to consume alcohol. It's also legal to, in this state, have marijuana or magic mushrooms. So to have discretion on the arrest, you could say makes sense, that if the potential offender is not interacting with the person who's covered by the protection order, if they're just at a bar with some friends, that's far different than texting the victim or going to the victim's house or in any ways crossing the threshold of the place where the alleged perpetrator was told not to be under the protection order. And with that, I will say, we would come to view this as, certainly one that has a reasonable outcome. So I, appreciate the amendments that have gotten us to this place. We do need to have some discretion built in, that it's not necessarily the use of substances that causes a person to violate the protection order. It tends to be the excessive use and then interacting with the victim. And we should really be punishing when a person actually is interacting with the victim or is in a place they're told not to be under the protection order, rather than something that otherwise would be legal. It just so happens that law enforcement saw them there. So I would encourage members to vote your conscience on this bill. Thank you.
Representative Armagoss.
Thank you, Mr. Chair. And I echo a lot of the comments that were just mentioned. In judiciary, the issue I had with it is simply coming down to the alcohol and recreational drugs. If somebody's given a criminal protection order, whether it's in the report, whether it's involved in the incident, reported involved with alcohol or recreational drugs, whether or not that's in the report or in the protection order, more often than not, those are involved in crimes against that victimize people. I think in any way, still allowing the consumption of alcohol and drugs is not going to do a good thing. It's not going to help any situation. So I didn't think that this was an exception that needed to be made. I don't think this makes the victims feel appreciated or otherwise taken care of or protected in this. So I don't like the idea of just allowing that as an exemption on these restrictions and criminal protection orders. So I was a no and would continue to be a no, just because to me that doesn't fit what we're trying to do to protect victims.
Assistant Majority Leader Bacon.
Thank you, members, and thank you to our colleagues. I will just point out that on the concerns, on the connections, this is why we had conversations with the victims' rights groups. They stayed on till 11 o'clock at night to share that we did have those conversations. They understand and they support, and they, with the amendments, got to neutral. If someone is intoxicated, that is a separate crime. They could be arrested for that. We are talking about if someone's literally near or even possessing, you can go to the grocery store, buy something for someone else. You can be in a bar when a fight breaks out. You don't even have to be drinking and you could be arrested. Furthermore, mandatory arrests are also putting burdens on jails. It is not free to put someone in jail overnight that didn't do anything connected to the underlying crime. And also, as a matter of jurisprudence in this country, you know, you arrest people when they have broken laws. People are still innocent until proven guilty. And all we're saying here is that sometimes the provisions of this aren't connected to the actual crime. And until they are otherwise proven guilty, we shouldn't have system making things illegal for them that wouldn't otherwise be illegal elsewhere. We're talking about someone being at a birthday party who has a protection, or in Denver, who has a protection order against someone who is in Pueblo. They're not anywhere around. And so again, this is discretionary. It's not to even say that it doesn't happen. Law enforcement will still have the opportunity to make that decision. And so with that, members, we urge an aye vote.
Seeing no further discussion, the question before us is the adoption of House Bill 1148. All those in favor say aye. All those opposed, no. The ayes have it. The bill is adopted. Mr. Schiebel, please read the title for House Bill 1179.
House Bill 1179 by Representatives Okai and Ferre, also Senators Doherty and Judah, concerning automobile insurance coverage for the replacement of a child restraint system.
Representatives Okai.
Thank you, Mr. Chair. I move House Bill 1179 and the Business Committee report.
To the committee report, Representatives Okai.
Thank you, Mr. Chair. We had a lively discussion in Business Committee, and we did offer an amendment with some technical changes, as well as adding the requirement for insurance companies to ask the claimant if there was a car seat in the vehicle at the time of the accident. I also have an amendment. I move L002 to the Business Committee report and ask that it be properly displayed.
That is a proper motion. We'll wait for it to be displayed. Representatives Okai.
Thank you, Mr. Chair. This is a technical change that clarifies that it is the applicable auto insurance coverage that applies to this policy. And I ask for an aye vote.
Just 1 second. Is this to the committee report?
It's to the committee report.
Okay. My apologies. Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L002 to the Business Affairs and Labor Committee report on House Bill 1179. All those in favor say aye.
Aye.
All those opposed, no. The amendment is adopted. To the committee report, Representatives Okai.
To the committee report? You talking about what you did in committee? We already did that. I thought we already did the committee report.
You're still on the committee report. You just made an amendment to the committee report.
Oh, okay.
Is there any further discussion on the Business Affairs and Committee report?
No. No.
Seeing, yes, no?
Nope.
No. Seeing no further discussion, the question before us is the adoption of the Business Affairs and Labor Committee report as amended on House Bill 1179. All those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill, Representatives Okai.
Thank you, Mr. Chair. I'd like to start by acknowledging the little person who's the inspiration behind this bill. Someone very important to me that I haven't seen as much lately with our committees going late. But Rayhan, or as we call him, Ray Ray the baby, is a feisty, sweet toddler. And when he was a little baby, we were in a car accident. And we knew that we no longer could use that car seat, but the insurance company refused to pay for a reimbursement. So we instead were moving the car seat we had between our two vehicles until we were able to set aside enough money to buy a car seat that would be safe for him. And in venting about this story and talking to parents about this story, I've learned that many parents are unaware that if you have a car seat in your car, even during a minor accident, that car seat does need to be replaced and is no longer safe, it's no longer protecting your child. And in stakeholding this bill with healthcare experts, I have heard heartbreaking stories of what happens when we have kids in those car seats that are no longer protecting them. This bill requires insurance companies to reimburse the cost of a car seat that is in a vehicle during an accident. It also requires the insurance company to ask the claimant if there was a car seat in their vehicle. When we have families that are facing something unexpected, we should make sure that they are not burdened by these unforeseen expenses, and this bill will help keep our little Coloradans safe. I urge an aye vote.
Is there any further discussion on House Bill 1179? Representative Richardson.
No, I absolutely understand the intent behind the bill, and I think the intent is good. But unfortunately, this is yet another bill that adds costs to everybody in Colorado that drives a car, whether they have a car seat or not. So requiring insurance cover a car seat, whether somebody has a car seat or not, under their insurance adds costs. It's very simple. And the other, and I do dispute that car seats do not have to be replaced after minor accidents. There's definitions within the National Traffic Safety Administration that dictate what is a minor accident and, you know, when a car seat should have to be replaced. It may be a parent's desire, and I would understand that desire to make sure your child is safe, but there is no requirement in a minor accident as defined by the NTSA to replace a car seat. It's moderate accidents and severe accidents that require replacement. So again, a very good idea, but it does add cost to everybody in Colorado, and that's what we're trying to reduce here. So thank you.
Representative Sukla.
Thank you, Mr. Chair. It is a well-intended bill. The problem is I'm a mountain biker, and every time I wrecked my mountain bike, I had to replace my helmet. I couldn't. It cost more than the mountain bike cost me because I've wrecked that mountain bike a lot. The deal is I want to talk about the people where I live, and we live in a poor area. Car seats actually are bought at a lot of yard sales where I live. And if you're going to raise the insurance for everybody, I think we're just getting too far into the weeds on insurance. You're going to raise the price of insurance for everybody. And I believe that we're doing just fine without this bill. Thank you.
Seeing no further discussion on House Bill 1179, the question before us is the adoption of House Bill 1179. All those in favor say aye. Aye. All those opposed, no. The bill is adopted. Mr. Shebel, please read the title to House Bill 1116.
House Bill 1116 by Representatives Armagost and Bacon, also Senator Pelton R., concerning requiring the Department of Corrections to search for information related to an offender's court appearances.
Assistant Majority Leader Bacon.
Thank you. I move House Bill 1116 and the Judiciary Committee report.
To the committee report. Assistant Majority Leader Bacon.
Sorry, thank you. In the committee report, we changed the terms to bring down the fiscal note a little bit, whereas in the bill, we said there were a few times that DOC could check to see if there are outstanding warrants for those who are incarcerated there, and we changed it to just one term in the middle. I think it's around 6 to 8 months before they are released, that DOC should do a warrant check. But also, Mr. Chair, I move L2 and ask that it be displayed.
That is a proper motion. That is displayed. Assistant Majority Leader Bacon.
Thank you, members. This is a technical fix that our drafter pointed out, and so we urge an aye vote.
Seeing no further discussion on Amendment L002 to the Judiciary Committee report, all those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. To the committee report. Seeing no further discussion on the committee report, the question before us is the adoption of the Judiciary Committee report to House Bill 1116. Please, all those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill, Representative Armagost.
Thank you, Mr. Chair. So this bill was brought forward to my attention from one of our fine sheriffs in southeastern Colorado. And it's something where we have a lot of inmates that are released from DOC, and their warrant check wouldn't be done until just before or just during the time of their release, and find out they have something, a low-level failure to appear or a warrant in a county that they have to then be transported to, and it would be on the county sheriff to transport them to their county, hold them for their hearing, and basically when somebody's trying to get released, paroled from prison, then they end up getting right back into the system. It increases recidivism. It puts that burden on our sheriff's offices and on our taxpayers, essentially. So this is something that will create a larger window, that 3 to 8 month window, where DOC can do, and the public defenders can do those warrant checks. Make sure that they don't have any outstanding warrants. If they do, they can resolve those during their time while they're incarcerated. We don't have the recidivism. We do have the people that are given the ability to reintegrate into society, and we don't have to burden our sheriff's offices and local municipalities to transport people to their counties when they're trying to get back to their families on something that could have been resolved while they're incarcerated. So this bill helps all of that. It's a good common sense bill to reduce recidivism and take that burden off of our sheriff's offices, so I encourage a yes vote.
Seeing no further discussion on House Bill 1116, the question before us is the adoption of House Bill 1116 on second reading. All those in favor say aye. All those opposed, no. The ayes have it. The bill is adopted. Mr. Shebo, please read the title of House Bill 1014.
House Bill 1014 by Representatives Johnson and Lukens, also Senators Roberts and Simpson, concerning measures to increase efficiency in division of water resources processes.
Representative Lukens.
Thank you, Mr. Chair. I move House Bill 1014 and the Agriculture Committee report.
To the committee report.
Thank you, Mr. Chair. In committee, we brought a technical change to the applicability clause. We ask for a yes vote on the committee report.
Seeing no further discussion on the committee report for House Bill 1014 from the Agriculture, Water, and National Resources Committee, all those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill, Representative Lukens.
Thank you, Mr. Chair. I move Amendment L3 to House Bill 1014 and ask that it be properly displayed.
That is a proper motion. We will wait for it to be displayed. The amendment is displayed. Representative Lukens.
Thank you, Mr. Chair. Amendment L3 is in relation to the designated basin bedrock aquifer, and it adds a clarification on the definition of that. We felt that it was imperative to incorporate this into the bill, and we ask for a yes vote on L3.
Is there any further discussion on Amendment L003? The question before us is the adoption of Amendment L003 to House Bill 1014. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. To the bill, Representative Johnson.
Thank you, Mr. Chair. 1014 is largely technical, but it does help with water in our state, which is a major precious resource. This bill would help to eliminate unnecessary permitting requirements, reduce fees, and streamline work processes within the Department of Water Resources. And it would just help make things simplified, both for our ranching and ag communities, but across the state on the basins. I encourage a yes vote.
Representative Lukens.
Thank you, Mr. Chair. This bill makes process updates and improvements in 3 areas: water well permit expiration, groundwater permitting, and the water rights abandonment process. We ask for a yes vote on House Bill 1014 as amended.
Seeing no further discussion on House Bill 251014, the question before us is the passage of House Bill 1014 as amended. All those in favor say aye. All those opposed, no. The ayes have it. The bill is adopted. Laissez les bon temps rouler, Madam Majority Leader.
Thank you, Mr. Chair. I like that. I move the committee rise and report.
The committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bills 1011 is amended, 1014 is amended, 1116 is amended, 1148 is amended, 1168 is amended, 1179 is amended, and 1200 is amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Representative Clifford. Woohoo! Members, you have heard the motion. There are no amendments at the desk. The motion before us is the adoption of the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Representative McCormick. Please close the machine. With 41 aye, 21 no, and 3 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader. Members, we are moving straight to thirds. I will invite everyone to take their seats. Mr. Shebel, please read the titled House Bill 1205.
House Bill 1205 by Representatives McCluskey and Brown, also Senators Amabile and Roberts, concerning measures to facilitate the implementation of fair access to insurance requirements plans.
Madam Majority Leader.
Madam Speaker, I move House Bill 1205 on third reading and final passage.
The motion before us is the adoption of House Bill 1205 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Please close the machine. With 46 ayes, 16 no, and 3 excused, House Bill 1205 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1090.
House Bill 1090 by Representatives Sirota and Ricks, also Senators Weissman and Cutter, concerning protections against deceptive pricing practices.
Madam Majority Leader.
Madam Speaker, I move House Bill 1090 on third reading and final passage.
The motion before us is the adoption of House Bill 1090 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Please close the machine. With 41 aye, 21 no, and 3 excused, House Bill 1090 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1113.
House Bill 1113 by Representative Smith and McCormick, also Senator Roberts, concerning limiting the use of certain landscaping practices in new residential development.
Madam Majority Leader.
Madam Speaker, I move House Bill 1113 on third reading and final passage.
The motion before us is the adoption of House Bill 1113 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Clifford and Leader. Please close the machine. With 41 aye, 21 no, and 3 excused, House Bill 1113 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1161.
House Bill 1161 by Representative Valdez, also Senator Kipp, concerning requiring the labeling of gas-fueled stoves.
Madam Majority Leader.
Madam Speaker, I move House Bill 1161 on third reading and final passage.
Representative DeGraff.
Thank you, Madam Speaker. It just occurred to me last time, one thing I forgot to mention is that most of your stoves vent back indoors, and that's required, that's just part of the code. The general is that it does vent to the outside, but the most, if you have a microwave above, or most vents, because it requires, you have to have a smooth pipe that goes out through the wall. It can't be any corrugations. So it ends up being vented right back into the house. So whatever you're trying to get out of that by this whole process is just most likely is coming right back into the house, so it doesn't really do anything. Most of what comes off of that is CO2 and H2O. If you look at the stoichiometry of that, CH4 plus some O2s comes out to carbon dioxide and water. And if you really want to deal with the fallout of having a gas stove, what you should probably have is a plant in your house, because plants tend to love CO2 and water. So the other part about venting to protect your plants from CO2 and water is that when you run a fan just for the sake of cooking, if it's not for fumes or anything like that, what you're actually doing is you're pumping conditioned air outside of the house. You're taking warm air in the wintertime and pumping it outside the house, a lot more cubic feet than you would need to. Or in the summer, you're pumping cooled air outside of your house, a lot more than you would need to. And again, all to protect your plants from CO2 and water. So I know you'll vote for this anyways because it's a feel-good bill, and I just wanted to know, everybody to know that I will make fun of you for it.
Seeing no further discussion, the motion before us is the adoption of House Bill 1161. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote? Representative Lindsay, you are on mute.
Oh, yes, sorry.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
No.
Representative Gonzalez votes no. Representative Bottoms. Please close the machine. With 41 aye, 21 no, and 3 excused, House Bill 1161 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1176.
House Bill 1176 by Representative Stewart R., also Senators Simpson and Michelson Janae, concerning measures to reduce the stigma of behavioral health treatment for medical practitioners.
Madam Majority Leader.
Madam Speaker, I move House Bill 1176 on third reading and final passage.
Seeing no further discussion, the motion before us is the adoption of House Bill 1176 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 55 ayes, 7 no, 3 excused, House Bill 1176 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1108.
House Bill 1108 by Representatives Weinberg and Mabry, also Senators Kirkmeyer and Bridges, concerning limitations on residential rental agreement terms in the event of the death of an individual who is responsible for the payment of rent.
Madam Majority Leader.
Madam Speaker, I move House Bill 1108 on third reading and final passage.
Representative Weinberg and Representative Mabry.
Thank you, Madam Speaker. I request permission this morning to offer a third reading amendment to House Bill 25-1108.
Thank you. Representative, briefly explain.
So, fellow colleagues, members of the 75th General Assembly, this bill was really close to my heart on this one. It came from a gentleman out of my district who's actually here with us today with his family. He was done wrong. And what this amendment does is actually names the bill after his mother. And yeah, you feel bad about now, huh? There are small things in this building that we have, and this one is near and dear to my heart, as it should be to your heart. And I think this is an excellent amendment on truly showing why we enjoy doing this job and why this is a good bill. So I would urge and I vote.
Seeing no further discussion, the motion before us is permission to run a third reading amendment on House Bill 1108. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 61 aye, 1 no, and 3 excused, the permission to run a third reading amendment is granted.
Thank you.
Representative Weinberg.
Thank you, Madam Speaker, and thank you, colleagues. Please be seated. I appreciate you guys very much. I'd like to move Amendment L005, and I ask that it be displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. Again, very simple amendment. I'm honored this morning to rise, not just to speak in favor of this bill, but to honor the life and legacy of Letitia Farrar, known to those who loved her as Letty. Letty was a mother, a friend, and a cherished member of the Loveland community. Her passing brought immense grief to her family, but what followed was something no family should have to endure, a financial burden placed upon them in the wake of their loss. It was their experience that brought this issue to light, and today we take a step toward ensuring no family has to face the same hardship in this state. In recognition of her story and the strength of her son, Carlos Hernandez, who is joining us in the chamber today, I am proud to say that this bill will now be known as Letty's Act. Carlos fought to make this right, and his determination has helped spark meaningful change in the good state of Colorado. This is more than just a change in a name. It is a promise that in Colorado, we will stand up for what is just and compassionate for all families. To Letty's family, we see you, we hear you, and we honor you. Letty's legacy will live on not just in the hearts of those who knew her, but in the law of this state, protecting families for generations to come. As a representative of House District 51 in the city of Loveland, I will always fight for all the people in my district. If there are problems that need solutions, I hope that we, as the state legislature, will always work together to fix them. And I urge an aye vote.
Seeing no further discussion, the motion before us is the adoption of Amendment L005 to House Bill 1108. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 60 aye, 2 no, and 3 excused, Amendment L005 is adopted. Members, let's all take a moment to recognize our guests. Thank you. Madam Majority Leader.
Madam Speaker, I move House Bill 1108 as amended on third reading and final passage.
The motion before us is the adoption of House Bill 1108 as amendment on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Basenecker and Soper. Please close the machine. With 53 aye, 9 no, and 3 excused, House Bill 1108 as amended is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1173.
House Bill 1173 by Representatives Lukens and Johnson, also Senator Kolker, concerning expanding the role of an advisory board to serve the Office of School Safety.
Madam Majority Leader.
Madam Speaker, I move House Bill 1173 on third reading and final passage.
The motion before us is the adoption of House Bill 1173 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote? Representative Gonzalez, you are on mute. Representative Gonzalez, how do you vote?
Sorry. I vote yes.
Representative Gonzalez votes yes. Please close the machine. With 54 aye, 8 no, 3 excused, House Bill 1173 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 46.
Senate Bill 46 by Senators Beers and Kipp, also Representative Taggart, concerning local government sales or use tax investigations and in connection therewith establishing uniform confidentiality standards for the protection of taxpayer information.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 46 on third reading and final passage.
The motion before us is the adoption of Senate Bill 46 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 61 aye, 1 no, 3 excused, Senate Bill 46 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1184.
House Bill 1184 by Representatives Pascal and Hartsook, also Senators Roberts and Carson, concerning community-based continuing care services for seniors awaiting admission to a life care institution.
Madam Majority Leader.
Madam Speaker, I move House Bill 1184 on third reading and final passage.
The motion before us is the adoption of House Bill 1184 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 50 aye, 12 no, and 3 excused, House Bill 1184 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1115.
House Bill 1115 by Representatives McCluskey and Soper, also Senators Roberts and Catlin, concerning the Colorado Water Conservation Board's administration of a water supply measurement program and in connection therewith making appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1115 on third reading and final passage.
The motion before us is the adoption of House Bill 1115 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Kelty? Please close the machine. With 52 aye, 9 no, and 4 excused, House Bill 1115 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1132.
House Bill 1132 by Representatives Camacho and Stewart R., also Senators Henriksen and Bridges, concerning creating the Military Family Behavioral Health Grant Program and the Veterans Mental Health Services Program and in connection therewith, reducing an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1132 on third reading and final passage.
Representative Armagost.
Thank you, Madam Speaker. And as many of you know, I support everything we can do for veterans. The only thing I can't support is the funding that I wholeheartedly disagree with, coming from Prop KK money on the excise tax on firearms, accessories, and ammunition. So I will be a no vote.
Representative Marshall.
Thank you, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you.
I just needed to come down and make just a quick comment because I'm going to be voting no on this bill. It went so quick on second reading because, of course, no one could ever vote against a veterans bill. But my concerns about it is it's so overly broad. It goes beyond what you normally would consider the core veterans community. And then when I ask about the core veterans community, so many have TRICARE, so many have the VA, then the question is, well, they're not all available. Well, we're getting to the point often where we're bidding against ourselves as the government, where we have huge mental health issues, but the supply of mental health providers is more of an issue than just throwing more money at it. So for those reasons, I don't feel I can vote for this bill. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. And my understanding still is that, well, it's based on the Prop KK, so coming from ammunition sales, and then if that doesn't happen, then it's going to pull out of the VHA funding. And if it's going to pull out of the VHA funding to help the very people that's supposed to be helped by VHA funding, why are we creating that? Also, if VHA, the veterans side, is already set up to deal with the veterans and their concerns and their sensibilities, it seems like that's a better place to leave the money. So I hope I'm not misunderstanding that, but that's when we went through the bill, that's how I understood it. That if say the state gutted ammunition sales by chasing all of the people that sell ammunition out of the state, then that money that's promised would come out of the VA, which is already doing the work. So, so I'll have to be a no.
Seeing no further discussion, the motion before us is the adoption of House Bill 1132 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Representative Bradley. Please close the machine. With 41 aye, 20 no, and 4 excused, House Bill 1132 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1221.
House Bill 1221 by Representatives Hamrick and Garcia-Sander, also Senators Bridges and Lundin, concerning authorizing Emily Griffith Technical College to offer an Associate of Applied Science degree.
Madam Majority Leader.
Madam Speaker, I move House Bill 1221 on third reading and final passage.
Seeing no discussion, the motion before us is the adoption of House Bill 1221 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Gonzalez, how do you vote?
Yes.
Representative Gonzalez votes yes. Please close the machine. With 60 aye, 1 no, and 4 excused, House Bill 1221 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine.
Do you have a bill up?
Mr. Shebel, please read the title to House Bill 1181.
House Bill 1181 by Representatives Clifford and Puglisi, also Senators Weissman and Lundin, concerning the Colorado Rangers Law Enforcement Shared Reserve.
Madam Majority Leader.
Madam Speaker, I move House Bill 1181 on third reading and final passage.
The motion before us is the adoption of House Bill 1181 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Joseph and Leader. Please close the machine. With 62 ayes, 0 no, 3 excused, House Bill 1181 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Members, that concludes third reading. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar to Wednesday, March 5th, 2025.
Seeing no objection, the balance of the calendar will be laid over until tomorrow, March 5th. Time for announcements and introductions. Rep. Mabry.
Thank you, Madam Speaker. Members of House Judiciary, we will be meeting in 107 in 15 minutes upon adjournment, so about 11:25. Please be there on time. We will be hearing House Bills 1185, Senate Bill 24, House Bill 1255, House Bill 1212, and House Bill 1067. 1227 and 1275 are going to be laid over to a later date. Thank you.
Thank you. Representative Brown.
Thank you, Madam Speaker. I did sign up today.
Woohoo!
Everybody clap. It's upon adjournment, 15 minutes upon adjournment, so let's say 11:25. Health and Human Services will meet in room 112. We will hear the following bills in the following order: 1204, 1259, 1213, 1279, 1259, 1256, and 1223. See you there.
Thank you. Representative Froelich.
Thank you, Madam Speaker. The Transportation, Housing, and Local Government Committee will meet at 1:30 LSB-A. A little bit of a switcheroo in terms of order. So first will be Senate Bill 6. then House Bill 1207, then 1236 is not happening, and then 1247.
Thank you. Representative Tatone.
Thank you, Madam Speaker. Good morning, members. Joint Technology Committee will be meeting tomorrow morning, 8 o'clock. We're going to hear from Judiciary, SER 352 8 a.m. Be there.
Thank you. Representative Joseph and Representative Hartsook.
Thank you, Madam Speaker. It is an honor to serve with you.
It is an honor to serve with you.
Thank you. Good morning, colleagues. As many of you know, we've been holding a donation drive to support those experiencing homelessness. Today, we are proud to share, thanks to the generosity of both our Democratic and Republican caucuses, we've collected over 5,000 items to help those in need.
Woo!
So I'd like to take a moment to recognize and welcome representatives from the Coalition for the Homeless and Heaven of Hope, two incredible organizations working tirelessly to support our unhoused veterans and families.
Representative Hartsook.
Good afternoon. Thank you, Madam Speaker. So this bipartisan effort was great because we did several things. We're addressing some of the root causes. We're helping them rebuild their lives. The point here is that there's a lot of caring and compassion that goes on out there. When we came together, we made a significant difference in this. And thank you to everyone who has contributed. Your John and Rusty continues to change lives. Thank you.
Woohoo! Representative Joseph.
Thank you, Madam Speaker. I would like for our chamber to welcome our guests. Please stand, the CEO and the Coalition for the Homeless, and also the co-executive director for Heaven of Hope and his group. Please stand up and we welcome them. Thank you, Madam Speaker.
Thank you. What a great effort. Representative Bradley.
Thank you, Madam Speaker. Members, hopefully you know who you are, but Statutory Revision Committee is meeting tomorrow, Wednesday, March 5th, 7:30 a.m. House Committee Room 107. We will be considering 6 bill drafts. Bring your coffee.
Representative Clifford. Oh, Froelich.
Thanks again, Madam Speaker. Today is also Bicycle Colorado Day. So bicycle, bicycle, bicycle. You're welcome, and hope you see them around town.
Thank you. Representative Clifford. And Representative Root, no. No.
All three, Madam Speaker.
All three.
On March 4th, we're going to have DRAD, which is the Disability Rights Advocacy Day. That's going to be from 8 to 12:30 in the West Foyer. There's also a press conference at 11:45 for those wishing to attend. Please join us for Disability Rights Advocacy Day, Thursday, March 6th. Thank you.
Excellent. Thank you. Madam Majority Leader. Oh, I have an announcement.
Okay.
I did. Representative Camacho will replace Representative Woodrow on House Transportation, Housing, and Local Government Committee for today only. Madam Majority Leader.
Thank you, Madam Speaker. I move the House stand in recess until later today.
The House will stand in recess until later today.